Hi, I'm Gordon Coyle, and today we're going to talk about what an action over claim is, or what an action over third-party liability exclusion is in your general liability policy. Action over issues are misunderstood by a lot of contractors and insurance brokers in New York. It's a pretty confusing topic, so we're going to simplify it. And to do that, we're going to give you an example. In this example, there's only three parties that we have to be aware of. The first one is the contractor, who's going to be doing a job or a project. The second party to this deal is an employee who works for the contractor. And the third party to this agreement is the project owner or the property owner. Now, prior to starting a job, the owner of the property or the project is going to send the contractor a construction contract. And within that contract is going to be an indemnity agreement, very common. An indemnity agreement, or a hold harmless agreement as we commonly call them, says something like that the contractor promises to indemnify and hold the property owner harmless from any and all claims which may arise during the course of construction. They'll also ask for a certificate of insurance naming the owner and maybe other entities as additional insureds on the contractor's policies. So during the course of construction, the employee, party number two that we talked about, is injured during the course of construction. Normal workplace injury, but it's pretty serious. So the employee files a claim with the contractor's workers' compensation insurer. The claim handles all of the medical bills and pays the lost wages while that worker's out of work. Now, halfway through this claims process, the employee decides that they're going to also sue the property owner for negligence for failure to maintain a safe workplace. Now, we don't need to talk about whether the workplace was safe or unsafe, or who had control of it or who didn't have control of it. The simple fact is that we've got a multi-million-dollar lawsuit that the employee has filed against the property owner. Now, the property owner is going to take that lawsuit and they're going to tender it or give it over to the contractor. Under the terms of the construction contract we mentioned earlier, the indemnity agreement makes the contractor responsible for any and all claims which could arise from the performance of that job, and this is one of them. So the contractor takes that claim now and they brings it to their insurance broker. Now here's the rub. Contractors' insurance in downstate New York, especially in the 5 boroughs, can get very expensive. So this contractor decided that they were going to exclude action over liability in their general liability policy, and that's a real problem. Another way this can happen is that an unscrupulous broker may be competing on a contractor's liability insurance and bid 30 to 50% less, and we've seen this happen, and they don't disclose why it was so much cheaper. And the reason it's cheaper is because action over claims are excluded, and unfortunately the contractor didn't ask enough questions, and action over claims are going to be excluded. However it happens, whether it was the contractor just trying to save a few dollars or it was due to an unscrupulous broker, it really doesn't matter at this point. The contractor has a multi-million-dollar lawsuit on their hands. They've got a contractual obligation to indemnify for it, and what are they going to do? They're either going to try to give it back to the property owner. They don't want it. The property owner's liability insurance company doesn't want it. They'll ultimately have to pay for it, but they're going to subrogate against the contractor under the terms of the contract. So what ultimately happens in many cases is that the contractor has to go bankrupt. It's probably not the best situation. You've put your entire life's work into a business, and now you have to go into bankruptcy because you didn't have the right insurance coverage. Now, what compounds this problem even more in some situations is that endorsements or exclusions in some liability policies don't specifically say action over claims excluded. They're going to have different wordings, and it's going to mask the problem. I'm going to read some of the titles of these exclusions. They can be amendment to employee injury exclusion, or amendment of definition of employee injury, or carve back of contractual liability, or something else like that. And like I said, that masks the real issue. So you may not even understand that you don't have the coverage even if you read your policy. Look, I realize that liability insurance in the 5 boroughs and downstate New York is really expensive. And if you're working at height, meaning you're on a ladder or a scaffold, you're a painting contractor, masonry, drywall, those sorts of trades, it gets even more expensive and very limited availability. But the question is do you want to have coverage for third-party action over claims, or not. And I really recommend that you'd have action over coverage, because these kinds of claims happen, they happen with regular frequency, and they get very expensive. What's the solution? Well, unfortunately, there's no way around the pricing situation. Action over coverage for contractors in New York is expensive. There's no changing that. The only solution I can give you is that you have to read your policy. Make sure you understand what's included and what's not included. If you're not sure, ask questions. If you're not sure you're getting the right answers, ask for a second opinion. You might even want to get your broker's responses in writing, so if there's a misunderstanding somewhere down the road, you've got it and it's documented. The other thing I'd recommend is read your contracts. Many times contractors don't thoroughly understand everything that's within a construction contract, which puts them at risk. If you need help in this area, contact your attorney, ask them to unpack what's inside these documents so you can understand them. Generally, they're not negotiable or very difficult to negotiate, but you'd really want to understand that you're not getting taken advantage of here. I hope that helps shed some light on a kind of confusing topic regarding action over claims, especially in New York. If you have any comments, questions, or thoughts that you'd like to share with me, why not drop me an email or give me a call. My contact info is at the end of this video. And I really appreciate you watching. If you have any comments you'd like to leave in the comment section below, that'd be great. Thanks a lot.